Start. Assuming that the labor court did make an award, but since same was not published, comma, it was open to the presiding officer to pass a fresh award, full stop. There is no allegation of malafide or extraneous consideration, and comma, consequently, comma, the court is of the opinion that so long as the award was not published, comma, it was open to the labor court to review its own order, comma, which had been reserved and which had not been published, full stop. The court has perused the award and the findings given by the labor court on the various charges, full stop. The court finds that only charge number 5 has been proved and other charges have not been proved, full stop. The labor court has considered the evidence and has applied its mind, comma, which the court does not find any fault, full stop. The reasoning given by the labor court is based on the material evidence on record, comma, which this court is not inclined to interfere in a writ jurisdiction, comma, since the court does not find that the finding of the labor court is perverse, full stop, para. Even for the sake of argument, comma, assuming that the charge numbers 4 and 6 stood proved, comma, the court is of the opinion that the cumulative effect of these charges were not that grave, comma, which would commensurate the penalty of termination of the services, and comma, consequently, comma, on this ground, comma, the court is of the opinion that the order of termination was too harsh a punishment, full stop. Even though, comma, the labor court has gone into the evidence and has reconsidered the matter, comma, which it ought not to do so unless the inquiry proceedings were vitiated, comma, the court finds that the inquiry proceedings conducted by the inquiry officer was violative of the principles of natural justice, full stop. The inquiry officer has virtually given an ex parte report after considering various documents and reports given by various officers, full stop. Once an inquiry has been set up and a charge has been framed, comma, the inquiry officer is required to conduct an inquiry in accordance with the principles of natural justice, comma, meaning thereby, comma, that the inquiry officer has to cross-examine the witnesses and give an opportunity to the workman to cross-examine those witnesses, full stop. Giving an inquiry report on the basis of documents is by itself not sufficient, full stop. An opportunity to the workman ought to have been given, especially when the workman has denied charges, full stop, para. In the light of the aforesaid, comma, the court finds that the inquiry proceedings was not conducted in a fair and proper manner, and consequently, comma, the labor court, even though, comma, it has not set aside the inquiry report, comma, considered the evidence on record and gave its evidence, comma, the court is of the opinion that the award of the labor court could not be set aside on this ground itself, full stop. In the light of the aforesaid, comma, the court does not see any error in the award of the labor court with regard to the reinstatement of the workman and giving a lesser punishment commensurate of the misconduct, comma, which stood proved in relation to charge number 4, full stop, para. The court, however, finds that the order of termination was passed in the year 2003, full stop. Conciliation proceedings were initiated in the year 2004, reference was made by the state government in the year 2006, and the award was given in the year 2008, which was published in the year 2009, full stop. The court is of the opinion that considering these aspects, the award of full back wages is excessive and, consequently, in the light of the aforesaid facts, coupled with the principle of no work, no pay, this court is of the opinion that the award of full back wages is likely to be modified and is substituted to 50% back wages, but with continuity of service, full stop. In the light of the aforesaid, the word of the labor court is modified, full stop. The order of reinstatement with the punishment is upheld, and the award of the labor court of full back wages is modified to 50% back wages with continuity of service, full stop, para. It is a matter of breach of contract, which can be agitated before the civil court of competent jurisdiction, an ad hoc dealer has been appointed in place of the petitioner, full stop. It is a case where the payment of post-dated checks have been stopped by the petitioner, full stop. The petitioner was a habitual defaulter in making payment, as the checks were not dishonored once, but on several occasions, full stop. The petitioner was informed about the dishonor of checks through telephonic communication, full stop. There is no mandatory requirement of issuance of the show cause notice before suspension of sales and supplies of Messrs. HSD has as per the existing norms, full stop. Suspension was due to the outcome of non-transfer of funds to the respondent dash corporation, full stop. Shri Keshav would further submit that the petitioner has paid the balance amount after a much delay of demand, full stop. Accordingly, after ensuring full payment, the show cause notice was issued, full stop, over.